Scott Horton. I am founder and attorney with Horton Law PLLC, where I'm a labor and employment attorney representing employer organizations all around the state of New York, both private and public sector organizations and nonprofits and for-profit entities alike. This topic today applies essentially equally to all of those types of organizations and entities. Really, anyone who qualifies as an employer of at least one employee within the state of New York, which I suspect you all represent organizations that fit that criteria. Before we get started, I will just make a couple logistical notes. Again, I will answer questions at the end. We will try to keep this to about an hour, but I will stay to continue to answer questions if it spills over. I will make the slides available to you at the end of the presentation. You will also receive an email after the fact by tomorrow that will also give you a link to the slides. The disclaimer I need to give now is that if you do ask questions, then recognize that whatever your name is entered into may show up in the chat window with your question, so try not to ask anything confidential. I can't provide any legal advice per se to any of you during this webinar because of the public setting. If you are my client, then obviously we can follow up and I can talk about your specific services or circumstances. Otherwise, this is information of a general nature. And finally, before I get started, I may editorialize from time to time on some of the guidance from the state. Please recognize that I'm not editorializing on the topic itself. Obviously, preventing sexual harassment at work is very important, and I don't mean to make light of that in any way, shape, or form, so there won't be many jokes throughout this presentation or anything like that. But again, my comments are more focused on, at times, critiquing some of the requirements from the state, largely out of concern that they may not be effective, or at least not effective in the way that they're intended to be. So with that, let's get started with just a very brief overview. Most of this is going to go specifically into the new policy and training requirements for sexual harassment in New York State. The first slide I want to present just is to roughly show the scope and what workplace sexual harassment refers to. There are state and federal laws. If you happen to be in New York City, there is a very relevant New York City law as well, the New York City human rights law, that also has extensive protections against sexual harassment at work. I'm not going to go into the New York City details here, mostly because the bulk of you are not in New York City, and also because the requirements for New York City will be changing early next year, and that will be a topic for that time. But if you do have employees in New York City, keep that in mind, and you may need to make additional efforts on your policies and training as a result of the requirements of that separate law. Under federal law, Title VII prohibits sexual harassment among certain other forms of discrimination by employers with 15 or more employees. The U.S. Equal Employment Opportunity Commission receives charges for violations of Title VII, and the EEOC has recently demonstrated an intentional focus on redressing sexual harassment. They have filed a number of lawsuits in sort of concerted fashion, all in the same day, for example, across the country, to make it very clear that's an area of focus at the federal level. But really what we're talking about today is the New York State level, based on the New York human rights law initially, which prohibits discrimination based on a number of protected characteristics within employers of 4 or more employees. However, the human rights law has recently been amended to prohibit sexual harassment specifically by employers with even as few as 1 employee. So again, any employer of any size in New York State is prohibited from engaging in sexual harassment. And New York State employees have the option to file sexual harassment claims with the New York State Division of Human Rights, a state agency. They can also file those claims directly in court if they would like, or attach them to claims under Title VII filed with the EEOC. The other important recent change in New York State is that for sexual harassment only, the New York human rights law now encompasses claims by even non-employees within the workplace, so consultants, vendors, independent contractors, people that come into your employer workplace. So that's going to be, part and parcel of some of the policy and training requirements. However, the requirements do not require you to provide non-employees with policies or to train non-employees, but the policies and training should reference the coverage of non-employees as well. All right, so here are the big deadlines. And yesterday, the New York State Department of Labor updated its guidance. So at the end of August of 2018, they proposed initial guidelines on what the sexual harassment prevention policies had to include and what the training had to look like. And as set forth in those initial guidelines, your written policy has to be in place by October 9th, 2018. So that's next Tuesday, 1 week from today. The original guidance said that all employers would have to train all current employees by January 1st, 2019. That has been changed. Apparently, there was enough backlash, for example, among employers noting that this is the busiest time of year for many of them in retail, for example. You can understand the holidays coming up would be a particularly hard time to train employees, especially when they're bringing on a number of new, potentially seasonal employees, for example. So that annual training requirement now does not take effect until October 9th, 2019. In other words, you do still have to train all employees annually, but you have until October 9th of next year to do so for the first time. And then you will have to provide annual training, and we'll discuss that in more detail, but there's different ways you can determine what your year is for the purpose of measuring annual training. So I'm going to spend the first part and the bulk of this presentation talking about the policy requirements, because that is what is taking effect next week. Now, especially since we have a year to comply with the training requirement, I will still talk about what the new guidance is on the training, but I will not spend as much time as I might have if we were still facing a January 1st deadline. I just want to put up a quick poll and see among your organizations how many of you have already prepared what you intended to be your new sexual harassment policy. So if you could just take a second and click. This is anonymous. Nobody will know what you were responding individually. So we're getting some responses. It looks like about a third have prepared the new policy, which I'm assuming for now may include adopting the state's model policy. 2/3 of you have not. So that makes sense. That sounds about a reasonable breakdown. The ones of you who have prepared your new sexual harassment policy before yesterday afternoon when we got new guidance from the state, we'll now need to revisit what you had prepared to make sure it still seems satisfactory, and we're going to be talking about a lot of those requirements right now. Just real briefly, all of the documents that I'm going to be talking about are available on this website that New York State has created, Combating Sexual Harassment in the Workplace. This is just a partial screenshot of the cover screen for the website with the link below. Again, you will get a copy of these slides, so you don't have to jot that down now. Many of you have already been to that website, but again, that is where, as of yesterday, new sample and guidance materials are available now. The materials, of course, include the model policy that New York State Department of Labor, with assistance from the Division of Human Rights, was required to put out. The model policy, in my estimation, and I was up all night, not all night, but last night reading this and comparing it to the initial version, I think is improved from the initial public draft. I am sure that the state received numerous comments, although at this point I'm not aware that the comments themselves are available anywhere. They may become available at some point in time. But what we have is a revised policy that, again, I think is better than the original draft. Still not perfect or the way I would have written it, but I think it is better. It is 8 pages long, single-spaced, which concerns me a little bit. I am used to providing comprehensive anti-harassment policies that cover much more than sexual harassment, and I don't believe they've ever gone 8 pages single-spaced. The other thing that I find questionable is the fact that there are footnotes in the policy. I know a lot of lawyers and law students are originally trained to make sure to read the footnotes, but let's be real, not that many people really do read the footnotes. I'm not quite sure why they put footnotes in this policy, but they are there. And they, for example, advise the employees that this policy is based on sexual harassment, but that doesn't mean that other protected categories aren't still protected by law. It may be that you can eliminate those footnotes from the model policy if you choose. It's not entirely clear whether they are intended only for the employer's reference. It looks to me like they're not, that they are there to be part of the policy to go to the employees. I put at the bottom of this slide, there is footer language in the policy that says adoption of this policy does not constitute a conclusive defense to charges of unlawful sexual harassment, and then goes on. My personal opinion initially is that not probably necessary to leave that in the policy if you choose to adopt the model policy, that seems to be more guidance to the employer. But again, that's just an initial take, and I have not heard anyone else weigh in on that to this point. Couple of notes about the policy. Obviously, they've changed a lot of wording. It still looks substantially similar. There is no longer a reference to zero tolerance, as has been typical for quite a while. The original draft did reference a zero tolerance policy on sexual harassment. That's been removed. There's a fair amount of controversy over whether anti-harassment policies should be zero tolerance policies. I've written about this. I don't think having a zero tolerance policy is a bad thing. I think it's the right idea. The problem comes into who does and doesn't understand what zero tolerance means, and how well that's explained. What zero tolerance should mean if you're going to have a zero tolerance anti-harassment policy is that no form of harassment will be tolerated and therefore will be responded to appropriately, and there may be discipline that meets the circumstances. What many people, however, interpret zero tolerance to mean is that if you do anything that might violate the policy, then you automatically lose your job. And I'm sure that's why the reference was removed, out of fear that it would be interpreted that way, because there are examples of conduct that probably would be in violation of the sexual harassment policy that wouldn't necessarily in isolation automatically disqualify someone from employment. Of course, there are things that would violate the policy that would, in most cases, automatically disqualify someone from employment. The policy is one size fits all. There are no different versions based on what the nature of the industry is. So the same model policy is available for a manufacturing environment as for an office environment, as for an agricultural environment, as for a retail environment. I recognize it would be difficult and time consuming for the state to make separate policies for different industries, but it is a worthy critique, I think, to note that because this is not tailored to a specific industry, it may not be the best policy for everyone to adopt. In fact, the guidance from the state acknowledges that you may want to tailor your policy to better fit the nature of your workforce, for example, based on what industry you're in. As I kind of mentioned earlier, this only covers New York State law. To the extent there will be additional New York City requirements. The New York State policy does not specifically represent to satisfy those requirements, and by next spring probably would not. So that is something to consider if you have employees in New York City. You may have to have an additional policy, supplement this policy, or modify the policy next year. There is, and this is a potentially controversial issue, a notable emphasis on outside reporting. The law required that your policy, whether you adopt the model policy or create your own policy, include information about external protections and remedies. So it's understandable that it's in here. That includes explanations of the New York State human rights law, the Title VII protections at the federal level, and reference to possible local protections. And in fact, the policy concludes with the comment that if harassment involves unwanted physical touching, coercive physical confinement, or coerced sex acts, the conduct may constitute a crime. And then it says contact the local police department. Generally speaking, before these new requirements, I think employers rightly wrote these policies to focus on preventing and remedying sexual harassment, among other forms of harassment within the workplace. No employer really wants to send their employees to a government agency or to court. Clearly, you have to reference these additional remedies outside of the workplace, and the policy was otherwise modified in some small respects to still encourage internal reporting. But my personal initial impression is that an employer who wanted to could write their policy in a way that's compliant with the requirements and not do quite as much by way of encouraging employees to go to outside agencies. Again, that could be controversial depending on one's perspective of it, but from a standpoint of an employment policy and the fact that I represent employers, that is a potential concern that it may lead to more litigation than arguably may even be warranted if it leads to external complaints before internal complaints over comparatively minor circumstances that could have been corrected internally. Obviously, for the really bad employers out there that are doing horrible things, it's certainly appropriate that people go where they need to go to get that to stop and corrected. All right, so let's talk about your policy options. This is specific from guidance from the state. You may choose to modify the policy to reflect the work of your organization and industry-specific scenarios or best practices. So I alluded to that before. You still must meet required minimum standards, whether you modify the model policy or come up with your own policy. And we're going to go over all of those minimum standards individually. And you can distribute, this must be provided to each employee by next Tuesday, the 9th. You can distribute that on paper, hand it out, or send it electronically, such as by email. So you have those options as long as you can guarantee that it went to the employee. The electronic option is further nuanced by if you provide it electronically, then the employees have to have the ability to print a copy at work. This slide is too long for us to work through, but I just included it for when you do get the copy of the slides. If you want to print this one slide out and use it as a checklist of what the minimum standards are for your policy, you can do so, but we will talk separately about each of these, I believe it is 8 requirements. Before I go there, I just want to put up another poll on whether your organization is planning to use the model policy. So if you could answer this question. So it looks like the majority, or at least half of you, understand that your organization is considering using the model policy. Maybe about a third of you are saying, no, we're going to do our own. And some of you don't know. I'm going to assume that when you say you don't know, it's either you don't have anything to do with that decision or you're still deciding. So I'm going to conclude that roughly half, or a little more than half of you, and you come from all different types of organizations, are planning to use the model policy, maybe with some minor tweaks. And less than half of you plan to modify it more considerably or draft your own policy from scratch. And I'm going to compare and contrast and give some pros and cons of each approach as we wrap up. But again, these are the minimum standards if you either choose to modify the policy, so don't take these things out entirely, or if you're preparing your own separate policy, or for example, editing an existing policy. So first, the policy must prohibit sexual harassment consistent with guidance issued by the Department of Labor in consultation with the Division of Human Rights. So basically, this means it has to prohibit sexual harassment. That's not going to be the hard part of the policy for most people. This business about guidance issued by the Department of Labor. The Division of Human Rights actually issued guidance a few years ago, and it appears so far the Department of Labor is just endorsing that existing guidance. But this is, going to be good advice for sexual harassment prevention policies to prohibit sexual harassment, and otherwise you just want to prohibit it to the extent and scope of the law and what's protected, and or go beyond what the law prohibits and protects, which most policies will do. The prohibition on sexual harassment should also include examples of prohibited conduct. The model policy does this to some extent. For example, notes physical acts of a sexual nature, unwanted sexual advances or propositions, sex stereotyping, sexually oriented gestures, etc. So again, this is pretty common to be included in these policies. This is one area where possibly, depending on the nature of your workforce, your examples would differ. The examples in the model policy are relatively generic, which is not unusual. But if you already have a sexual harassment policy that includes some examples that perhaps were based on circumstances in your company or a similar company or something like that, it may be worth continuing to use those examples. And there's no guidance on how many examples you have to include, but you want to be probably pretty extensive to make sure that nothing that should be prohibited is left to question. The policy has to include information concerning the federal and state statutory provisions concerning sexual harassment, remedies available to victims of sexual harassment, and a statement that there may be applicable local laws. I talked about this a little before when I was saying that arguably the model policy goes above and beyond in promoting external reporting. I think this requirement could be met by simpler language explaining Title VII, the New York State human rights law, the possible local laws, and that the EEOC and New York State Division of Human Rights have the ability to receive complaints and what the time periods are. All that's in the model policy, but it goes a little further. Again, I'm not necessarily saying that you need to streamline that. I'm just saying that I think what is in the model policy is arguably much more extensive than what their minimum requirements actually set forth. The policy needs to include a complaint form. This is something that some of you have already been doing in your anti-harassment or sexual harassment policies in the past. It is probably not what the majority of companies have done over time. It is clear that if you receive a verbal, non-written complaint of sexual harassment, you should be taking it seriously and investigating, even despite the requirement now of a complaint form. And the complaint form that they have provided as a model, mentions that. The model complaint form is coming up later in this presentation, so I won't spend too much time on that. But again, you don't have to use the state's form, and there's not any further guidance on what the complaint form has to include. Your policy, like the model policy, has to include a procedure for the timely and confidential investigation of complaints that ensures due process for all parties. The gist of this makes a lot of sense. I mean, it's always been advisable to have a complaint procedure. This is consistent with EEOC guidance and what the courts have told us about how you may avoid liability for things that are beyond your control in the workplace. Having an effective procedure to receive complaints and investigate them and take appropriate action. Couple of things interesting about this requirement. One, it does say confidential investigation, which led to the model policy, the initial draft, saying that the investigation will be confidential. However, wisely, I believe the new version of the policy references that the investigation will be kept confidential to the extent possible, which has generally been the best practice to date. The minimum requirement here does still state the procedure has to be for a timely and confidential investigation, because that is what the statute itself passed by the legislature in the last state budget bill said. So I think the state is telling us it's okay to interpret that requirement to say that you will keep the investigation as confidential as possible, not that it will remain absolutely confidential, which could interfere with the ability to conduct the investigation in the first place and to take appropriate corrective action after the fact. The other picky complaint I have is the reference to due process. This is something different than constitutional due process, at least for any private employers. I suppose that public entities could be subject to constitutional due process with regard to these investigations. But, due process as a legal constitutional matter wouldn't strictly apply to private companies in the state of New York. So I think the best way to read this now is due process, meaning that it's fair for all parties. But we will see if there is further elaboration or challenge on that in the courts going forward. The policy must inform employees of their rights of redress in all available forums for adjudicating sexual harassment complaints administratively and judicially. So this is the flip side of the earlier piece. They're separated in here because this is the order they are in the documents from the state. But so you have to, I said before, tell them what laws are out there that they might have claims under, and then you have to tell them where they can go to make those complaints. But, again, my comment being that my preference as an employer representative and really even towards actually preventing and remedying sexual harassment before it really happens would be to focus a little bit less on sending people to outside agencies where they might be able to get some form of redress and go through a long process, and a little more focus on encouraging internal reporting so that minor issues could possibly get resolved before they escalate. But obviously the policy tries to do both. It's just a question of how you strike the balance. The policy must clearly state that sexual harassment is considered a form of employee misconduct and that sanctions will be enforced against individuals engaging in sexual harassment and against supervisory and managerial personnel who knowingly allow such behavior to continue. There's been some editing of the wording surrounding this in the model policy, but obviously the idea, is logical. So I don't think the exact wording is as critical as getting it in the policy, that if you violate the policy or engage in sexual harassment, then you may be disciplined or receive other corrective action. But you do not have to set any specific consequences for any specific actions. So as I was talking about before with the zero tolerance policy, the state has not read any zero tolerance requirement into the policy in a way that would mean that if someone engages in sexual harassment, they must automatically be terminated from employment. You can still weigh these circumstances and take the appropriate measures. Not surprisingly, the policy must state that retaliation against individuals who complain of sexual harassment or who testify or assist in any investigation or proceeding involving sexual harassment is unlawful. Again, these are the minimum requirements as set forth by the state, where they are basically copying from what the legislature passed in the statutory form. But it's interesting that their model policy has moved away from using the word complain towards using the word report sexual harassment, which I think is probably a valid word choice, more valid word choice under the circumstances. But, obviously the concept here being that retaliation is not okay, and that supervisors, can't take action against people for assisting in investigations, and coworkers can't, escalate or engage in new forms of mistreatment because someone has made a claim against them, for example. Okay, so that was all of the minimum requirements of your New York State sexual harassment policy. Now the big question, should we use the model policy? I'm not going to try to give you a yes or no answer to that. I'm just going to give you some of the pros and cons. You may have additional circumstances that makes one approach better than the other for you and your organization, but a couple of the obvious pros to the model policy are that it's guaranteed to satisfy the state requirements. The law pretty much spells out that employers will adopt the state model policy or a policy that meets the minimum standards. So as long as you adopt the state model policy, somebody's going to have a hard time telling you that you don't have a compliant policy, obviously. It's also comparatively quick and cheap to adopt the model policy. You don't have to spend all the time you might otherwise to draft your own policy or to modify the model policy. You can go right on the website and download the Word version of the state's model policy, enter your company or organization's name where they have highlighted a space for you to do so. If you want to take something out of the footer that I suggested might be a consideration before, or you have a font that you'd rather use, it would be pretty easy to get all of that the way you want it. The other advantage to the model policy, or potential advantage to the model policy, is it will be made available in other languages. At this point, I don't know that it is available in anything other than English, but the state has provided that it will be soon making it available in these additional languages: Spanish, Chinese, Korean, Bengali, Russian, Italian, Polish, and Haitian Creole. So if your workforce or significant portions of your workforce speak one of those languages, it may be an advantage to be able to download and use that version of the policy for the employees that are more fluent in those languages than in English. The guidance does suggest that if there's not a model policy available in the language that the employee speaks, you can provide them the English policy. But the whole point of the policy, of course, is to prevent and remedy incidents of sexual harassment. And if you give somebody a policy that they can't read, it's not likely to be terribly useful in doing that. If you create your own policy, then you arguably would have to provide it in the language that the employee speaks if there is a model policy available that is written in that language. But I don't know that that is entirely clear at this point. So what are some of the negatives of using the model policy? It might not fit with your other existing policies. Many of you, I'm sure, have pre-existing anti-harassment and discrimination policies that include sexual harassment among a bunch of other protected forms of harassment. If you adopt the state's model sexual harassment policy, you're going to need to review that policy to make sure they're not inconsistent, at least with respect to sexual harassment. And you probably don't want them to be inconsistent with respect to most other forms of harassment, because it's not clear that you should be treating sexual harassment one way and race-based harassment another way, especially with regard to what your investigation procedure is and the extent of guidance you give on outside forms of reporting. So you probably need to evaluate how your policies work together. You certainly, although not required by state or federal law per se to do so, are encouraged to have a broader anti-harassment policy that encompasses the myriad other protected characteristics. Despite the lack of a formal requirement, having that policy may provide you some defense to claims of those other forms of sexual harassment. And beyond that, it may also deter those forms of harassment or enable you to better take appropriate action when those types of misconduct occur. The model policy, as I've said many times, might over-encourage external reporting, again, coming from the assumption that as an employer, you would prefer to resolve disputes before they escalate and go outside of your workplace. The question that just came up, I'll go ahead and answer because I should have said this already. We have employees in other states. Can we use this policy for all staff? Well, yes and no is the answer. I mean, there are a couple of other states that have specific different requirements about training. For example, California is one that comes to mind. Every state, however, probably has its own, well, most states have their own sexual harassment laws, like the New York Human Rights Law. So to the extent that the model policy specifically describes the procedures related to the New York Human Rights Law and filing with the New York State Division of Human Rights, you probably would not want that in your policy for employees in other states. Arguably, if you provide them a policy with that in there, you may open yourself up to them filing claims in New York State where they might not otherwise be able to. I mean, that's a complicated legal question, but one that I would not want to get into. So I would say on the whole, you're going to want to keep this policy specifically to New York State employees, although large portions of it you could mirror in other states. And then, I put in here alternative approaches might be more effective at actually deterring, redressing sexual harassment. I mean, this, takes into account a lot of factors, and especially true, I believe, when we get to the training, which is coming up here in a minute. But again, based on the nature of your workforce, this policy is 8 pages long, single spaced. It is easier to read than the initial draft. They've pared down the wording a little bit in some cases, but I'm still not super optimistic that most of your employees are actually going to read this 8-page policy. So, if you were tailoring it specific to your workforce and knew your workforce, you could probably do a better job of writing a policy that would be meaningful to them. So that's just that as a general comment. It, also goes back to the question of, different states. Theoretically, you might even have different policies or at least different reporting procedures for different offices or facilities within your workplace, because they do have blanks for who you're supposed to report sexual harassment to, and that might vary depending on what building, location, etc. you're in. So you may need to modify the policy at least with some respect, or with respect to that, to point people in the right direction depending on who they are and where they are. One other thing that's interestingly not in the model policy is an acknowledgement of receipt. So as I put up here, New York State does encourage that you get the employees to sign off that they have read and received and read the policy, but they don't include that on the model policy. So if you're going to use the model policy, you probably want to create your own acknowledgement to include with it. And if you're using your own policy, then you want to, include an acknowledgement, because remember, beyond all the other traditional reasons why it's good to have the employees acknowledge that they are aware of these policies, but you are now, as an employer, or your employer whom you are assisting with this issue, is required as of October 9th to make sure that every employee has received the policy. So having some form of acknowledgement, which potentially could be electronic, will go towards demonstrating that you did what the law requires you to do in that regard. Couple minutes on the model complaint form, and then we'll go through the training relatively quickly, because again, like I said, there's potential for even more guidance to come out before that requirement really hits most of you now. The model complaint form is less cumbersome than the draft version. It is shorter The wording is less formal, which is nice. It eliminated some of the questionable items. The form originally asked for the employee who's filing the report to provide home contact information, which probably wasn't necessary and could be seen as an invasion of privacy. And it also had items asking the employee whether they've filed a lawsuit or administrative claim over the allegations that they're bringing in the complaint. That was eliminated for good reason, including that it potentially would be seriously frowned upon by the EEOC. But the complaint form now does ask as an optional item whether the complainant would like the employer to work with their attorney. It says, if you have retained legal counsel and would like us to work with them, please provide their contact information. Not sure what work with their attorney is and whether employers really want to have to be working with attorneys or whether they would feel compelled to do so based on the employee actually writing something in that space. I don't think that there's any requirement that you have to include something like that in your complaint form, but it is in the model complaint form. As with the policy itself, there's similar footer language. Adoption of this form does not constitute a conclusive defense to charges of unlawful sexual harassment. Personally, presuming there's no requirement, and I'm not clear that there is, I would be inclined to take that out before using the form with employees. And the third page is an instruction page, which I'll get to in just a second. So just so you have it before you, this is what the 2 pages of the complaint form that the reporting individual would fill out look like. It's relatively straightforward. Number 2, describe what happened. Before that was worded differently to say something like describe your allegations of sexual harassment or something. So again, this is more user friendly probably. It does say use additional sheets of paper. I mean, I think if I were preparing my own complaint form, I'd probably go ahead and allow more space to describe what happened. I write very small, and I could write probably a book under number 2, but a lot of people would struggle to get 6 or 7 words in that amount of space. As I mentioned, page 3 is instructions to employer, and it says if you receive a complaint about alleged sexual harassment, follow your sexual harassment prevention policy. I'm just not really sure whether this needs to be part of the complaint form. Hopefully, if you have adopted this policy or a policy that complies with the state requirements and you have a complaint form and someone fills it out and gives it to the right person, that whoever receives that is going to know they need to conduct an investigation. Again, I'm not clear that this is a requirement of your complaint form because as far as I can tell, there are no requirements for the complaint form other than that you have one and make it available to the employees. The model policy does say that the complaint form is attached to the model policy. There is other guidance where the state says as long as you have it available, it doesn't strictly speaking have to be attached. I think the better practice would be to have a complaint form included at the end of the policy. But again, it doesn't have to be the state's. There is also on that state website this model policy notice. I'm putting it here mainly to let you know clearly, as it says in the state's guidance, that this is optional. This is a sort of one-page thing where you would fill it in and post it on the bulletin boards where you post all the other employee notices to let them know that they have the right to file a complaint of sexual harassment. I don't have a strong opinion at this point on whether this is a good or bad idea, but I can tell you that you are not obligated to do it. And, you may choose to post something different. You may choose to post the actual policy or something that says more than what this says. So at this point, I'm just pointing that out because some of you will inevitably come across it on the website and either assume you have to do this or question what it is. So there it is. All right, like I said, I'm going to wrap up in just a few minutes now talking about the training requirements and then take questions. Again, feel free to answer or to ask questions before I get to the end if you have them, but I'll probably wait now to answer them at the end. The training requirement original deadline, according to the state, as of late August, or when they first put it out in late August, was that every employer must train every existing employee by January 1st, 2019. Not quite sure why they thought anyone was actually going to provide this training on January 1st, why they didn't just make it December 31st or whatever, but that was the date they came up with. Upon reflection, apparently the state has now decided that, well, annual training for a law that takes effect on October 9th, 2018 probably shouldn't have to be done until October 9th, 2019. I want to get real technical, I probably would have made it October 8th, 2019, but enjoy the extra day. I suspect a lot of employers will be wise to consider training in the spring. And depending on your workforce, you want to pick when it's easiest to get everyone available, depending on what method you're going to use for training, as we'll talk about. But as long as you do it for everyone by October 9th, you will be in compliance. You do have to do it annually after that. It can be based on the calendar year. So if you say do your training in July of 2019 and then decide to do the training next in October of 2020, according to the state guidance, that seems to be okay, even though it will have been more than a year since you did the training. So again, that's a little inconsistent. That might have been a logical reason why the original deadline was January 1st, 2019. But you can also choose the employee's anniversary date. So if you give every new employee training and when they're hired, and then just do it again by the end of their year with the company, you can do that. Or apparently you can pick some other date, presumably the same date every year. The logical date or the logical dates would be, let's stick with October 9th every year if that's what you're starting to use as your deadline, or the date that you first provide the training. So if you do the training on March 15th of 2018, make sure you do the training again by, March 15th, 2019, make sure you do it again by March 15th of 2020. I mean, it doesn't seem like that's going to be too hard to meet in a strict logistical sense of which date it is. You can pick and choose probably even between employees as far as we can tell so far. Of course, just providing annual training to every employee is going to be a headache for many of you regardless. The initial guidance said that new employees hired after the first training session had to be trained within 30 days. That has been essentially eliminated altogether, falling into whatever your annual training pattern is. So there's no specific time period for training new employees, but the state encourages training as soon as possible, consistent with the logic that the purpose of the training is to prevent sexual harassment. So unless and until you provide that training, you may not be able to expect that your employees know what they would have learned from the training and therefore may do something they should have not done or may not report something that they should have, etc. Here are the general training requirements. It has to be interactive training and include these different elements. These elements are pretty consistent with the requirements of the policy, and probably to do the training properly, you'd want to be training specifically what your policy is, whether you're using the model policy or something else. So again, explanation of sexual harassment consistent with the state guidance, examples of conduct that would constitute unlawful sexual harassment, information about the statutory provisions and rights of redress and available forums, and information about supervisors and any additional responsibilities that supervisors have to report sexual harassment, for example. That last item, there is guidance from the state that says that has to be included in training to all employees, not just supervisors. So both supervisors and non-supervisors alike have to be trained on supervisor responsibilities. You could potentially separate your supervisors and non-supervisors in training sessions, but that component still has to be met at least some minimum level for all employees. There is a frequently asked question where the state makes it clear that they have no specific time requirement for the training. You just have to meet all of these components, whether that takes you 20 minutes or 2 hours. My suggestion is that 20 minutes is probably too short and 2 hours probably wouldn't be unwarranted, but you have a lot of leeway in that depending on how you decide to have the training conducted. The training does have to be interactive, and in that regard, there's no real definition. The state just provides examples. They had some sort of guidelines in their original guidance in August that they seem to have backed away from, probably because it didn't make a whole lot of sense. So now they just give these examples. If the training is web-based and has questions at the end of the section and the employee must select the right answer, then that would be interactive. If it's web-based and the employee has an option to submit a question online and receive an answer immediately in a timely manner, that would be interactive. For in-person or live training, the presenter asks the employee questions or gives them time throughout the presentation to ask questions. So intentionally here, I've designed this such that probably this presentation that I'm giving, although wouldn't meet the requirements otherwise, would be considered interactive training. You all have the opportunity to ask questions. There were polls, for example, where you could provide information. So something like this format, may satisfy the interactive requirement of the training. Web-based or in-person trainings that provide a feedback survey for employees to turn in after they have completed the training. So that could arguably be something where there's no on-site at the moment interaction, but the employee has something that they can fill out and turn in after the fact. The one thing that the state guidance says on the other end of it is an individual watching a training video or reading a document only with no feedback mechanism or interaction would not be considered interactive. So you can't, stick people in a room, hand them a copy of your sexual harassment policy, tell them to read it, and then leave when they're done. Arguably that's training and the materials would probably include the minimum requirements, but there's no interaction involved. Probably would not be very effective training either, which is a valid consideration here. Let me go to the next slide real quick. Just another comment from the state. While a best practice for effective and engaging trainings, a live trainer is not specifically required. Live trainers may appear in person or via phone, video conference, etc. And no certification is required, and the state does not currently certify or license training providers. So with that thrown out, let me briefly tell you what the model training that the state has put out is. It's a PowerPoint presentation with 32 slides, no audio, visual, just words, a training script that's extensive and references sexual harassment case studies that are also shown in an additional PowerPoint slide presentation that's 66 slides long, Again, no video or images. This is available, and if someone stands in a room and reads this and answers questions, then I presume that the training would satisfy the state's requirements, but wouldn't necessarily be the most effective training that could be provided. So should we use the model training? There's, again, pros and cons. It should satisfy the state requirements. Before with the model policy, I said it's guaranteed to satisfy the state requirement. Here it should satisfy the state requirement because whoever's giving the training, I could foresee not presenting everything or not presenting everything properly. So, even if you use the right materials, if you don't present it in the right way, I suppose you could undermine the validity of the training. Again, it's pretty quick and cheap. Find somebody to read the materials and you arguably are there. And again, will be made available in other languages if that is a consideration. I know we are coming up on an hour and just have a very few more words to say, and then I'll take questions. So don't get concerned if you have to run. The cons, someone still has to present it. So do you have someone internally who is able to effectively provide the training based on what the state has put out there? And again, considering it needs to be interactive, someone needs to be answering questions. Do you have someone who will know how to answer the questions? There are no videos or images included, so it is probably a pretty dry presentation. At least I have a few images in this presentation, and whether you felt it to be dry or not, the point is that you want the employees to take this seriously. You might be giving the exact same training each year if you just use the model policy, which could obviously get very boring to your employees. I would think best practice would be to try to mix it up in some way, shape, or form. And again, alternative approaches might be more effective at actually deterring, redressing sexual harassment. I had a question come in about whether the training has to be separate from other types of training. There's no clear guidance on that. I think the state is dodging the question because I'm sure they've been asked it, especially in the context of whether you can do a training that encompasses all forms of harassment, not just sexual harassment, so race and age-based harassment, etc. I think for now, we have to assume the best practice is to make sure you have a sexual harassment component. But if you spend the first 45 minutes talking about harassment generally and other protected categories, and then hit all of the sexual harassment required material as part of the presentation, I would hope that that would satisfy the state. I think that would be more effective training than just having standalone sexual harassment training, because I fear that sexual harassment training can put half of the workforce on one side and half on the other, meaning men versus women generally, where at least if you talk about a whole host of protected characteristics, that gives everybody a greater chance of seeing themselves on different sides of the circumstances. So again, that's my general recommendation, always has been, but I would do enough to make sure that you've met all of the specific requirements for the sexual harassment training in the context of whatever way you're presenting it. So with that, we have gotten to the end. I will answer questions. There's at least one comment that has come through that I will address. Go ahead and ask other questions at this point in time. I will put up the link to the slides in just a moment. Again, you'll get that by email if you can't wait. The comment was, as an employer in the current litigious environment we operate in, I worry that the increased visibility may encourage complaints that would have otherwise faded away. I mean, it's a valid concern. There's going to be more litigation over sexual harassment and maybe other forms of harassment and discrimination than there would have been before. Whether that's good or bad depends on perspective and circumstance. Again, my biggest concern with it is that it will lead people to go pursue claims in litigation when the better recourse for everybody involved would be some form of internal investigation and redress. Again, there are clearly circumstances that are utterly unacceptable and warrant involvement of outside authorities. But, the first stray comment that someone makes won't necessarily provide someone a viable claim under the New York Human Rights Law or Title VII, but may be enough for them to file a complaint with the Division of Human Rights and initiate a year-long investigation that ultimately results in the complaint being dismissed and no one being happy. Whereas the same comment could have been addressed within the workplace quickly, and hopefully the interpersonal dynamics would have dramatically improved and there wouldn't have been problems. So it all depends on circumstances. It's obviously an issue of considerable focus in our society, including workplaces. For now, we have these requirements on the policies and the training, and the biggest thing for employers is, and what are the penalties? I mean, there are probably specific monetary fines available. They're not specific for this requirement, but for general violations of the New York State labor law, which is where this falls. But the biggest penalty for not having these things done properly would be if you then faced a sexual harassment complaint as an employer. You would be way behind the 8 ball in trying to defend your case if you didn't have the required policy and hadn't provided the required training. That's going to become a major issue in all of this litigation, the extent to which those requirements have been complied with. I don't anticipate the state actively running around auditing employers to see whether they've done this training in most cases, unless there's some particular reason to be in your workplace for something else where they may check for it. But again, when litigation arises, if you're not able to show that you did what was minimally required by state law, then it's probably going to make it more difficult than it otherwise would have been to prevail on a sexual harassment case. Because let's keep in mind that often the employer facing a sexual harassment complaint is not being alleged to have personally perpetrated sexual harassment. Whoever the president or owner of the company isn't necessarily the harasser, although obviously they can be. So the liability often hinges a lot more on what the company knew and didn't know and what they should or shouldn't have done about the circumstances that did exist. And if you haven't done the right thing by way of having your policy and conducting your training, then presumptions will likely be made that you knew more than you should have, but just were turning a blind eye to something that you shouldn't have been. I'm going to put up the link to the slide. Thanks for being patient, because I know you want those. I will still look for any more questions that you may have, but again, Tuesday, October 9th, every New York employer with at least one employee must have provided a written policy on sexual harassment that meets the state requirements to all employees. Your training obligation now does not come into play until the October 9, 2019 deadline. Granted, you don't want to wait until the last minute, but you have now 53 weeks to figure out how you're going to meet that requirement. I suspect there will be many ways to do that. There will be video trainings, webinar trainings. There will be presenters available. I do this type of training for clients as well. It's not that it's hard to find a way to do the training. The logistical problems, the costs, the reaching every employee, etc., will be the problem. There is a frequently asked question or other guidance from the state on the question of what happens if I can't get my employee to participate in the training. And the state's answer is basically tough. It's your obligation as the employer. I suppose their answer comes down to if you can't get them to show up for the training or do the training, then you should get rid of them so that they're no longer your employee and it's not your fault that they're not trained. So that could be a problem if you have an employee who is absent the day that you were planning to do plant-wide sexual harassment training. I don't think there is any exception to be made there. You will have to let that person make up the training in some other way, shape, or form. There is also nothing discussing the circumstance of an employee on leave, or at least nothing that I'm aware of yet on what happens there. So if you have an employee out of work on an extended leave, that could raise a question. I'm not sure that you would or could be expected to have them even do online training or anything from their home. So perhaps that would be considered a situation where the person just wasn't an employee effectively at the time. But if you have someone who happens to be out 6 months out of your 12-month year, I see it possible that the state would still expect you to find time to train them in those other 6 months. So perhaps only the case where someone is actually out of work for the entire year or virtually the entire year would you get an exception. But again, that's an untested situation at this point. Any other questions? So most of you are happy that you don't have to get training done by the end of this year. So that's good news. The policy is really what you need to be focusing on immediately. I'm happy that new guidance came out yesterday so that I could share it with you this morning or today. Otherwise, I would have been talking about guidance that was about to get considerably modified. So I don't expect at this point the state to make any meaningful changes to the model policy or its guidance before next Tuesday. There may be changes or additional information, beyond that, potentially related to the training that have to be done next year. I will try to provide another webinar if there is any substantive revision or, serious revision going forward. I will also continue to provide these webinars on a roughly monthly basis on other topics. As always, I welcome your input on what topics you would like to see in the future. And otherwise, I just appreciate your time today and wish you luck in complying with the state's new requirements. Thanks, everyone.